I got a few extra minutes, so a bonus video today. Let's go ahead and cut through the crap and talk about a recent Supreme Court decision that is being slightly misrepresented in how it went down. In this particular case, Schneider was a mayor of a major city who awarded several contracts to a trucking company. After he left office, he was given gratuities in the form of, I think it was like $13,000 from various firms in appreciation for his consulting services. The FBI stepped in and said, it's obvious you're getting kickbacks and being bribed to provide these specific contracts to these entities. The Supreme Court disagreed. They said this is not a bribe, this is a tip given after the person left office, and therefore it does not qualify as the DOJ qualifies. And if you read the brief, you'll find out that they're fundamentally correct. Now, I've heard the same news reports all of you have. It's now legal to tip after the fact. Oh, we've just decriminalized the ability to influence people through monetary payments. Yet, if you actually read the brief, you'll find out that that's not exactly what they said. Now, if you go ahead and take a look at this section just above me, what you'll find that the Supreme Court actually found was the specific law code that the DOJ and FBI cited, that being 666, passed during the Reagan era, covered specifically bribes. It did not cover gratuities. Now, that's not to say that you can't have a law against gratuities. What the Supreme Court is actually saying is the law code actually cited by the DOJ and the FBI does not cover gratuities, and that's the reason that they ruled the way that they did. Essentially, what SCOTUS is saying is that we have no problem with you making a case that a gratuity can be used to influence a person after a ruling or a contract can be given out. However, you can't cite it under this law code. Essentially, you guys filed the wrong law, gave the wrong law code, and we cannot convict the individual on the basis of that, and hence we cannot hold in your favor. Later on in the brief, you'll also find out that it says that the entire case is remanded, meaning they're sending it back down to Congress and to the lower courts to have further adjudication over proper law code or to develop a proper law code to address the situation. Yet, if you watch the media, you'll think that an activist Supreme Court somehow stepped forward and said, you can't do bribes, but man, just hold off until after you leave office and have a promise of payment. Money's just going to keep rolling through. No problem, man. And to cover the fact that there actually is an anti-gratuity statute, 3.101-2 covers this and said that governmental employees may not accept tips or gratuities. The Supreme Court could weigh in quite easily and say that could be after the fact or during, but still it's a tip, not a bribe, and this would be a better statute to file under. Always question the given narrative, never believe what you are told, and do your own research. I'll talk to you next time when we talk about another thing I find interesting. I'm out.